The month of July has seen very many murder suspects convicted. Out of the murder suspects convicted, all of them are men. So Bramwell was asked, why is the judiciary dealing with the boy child badly? Yet, the only lady who was at the murder trial, Maxine, was released, was acquitted. Courts of law are courts of evidence. If there is no evidence, the judges will acquit. So the argument that she was acquitted because she was a woman does not hold any water. The argument that the other 6 men were convicted because they are a boy child, that doesn't matter. Welcome to Court Helicopter Trending Issues. The month of July has seen very many murder suspects convicted. Out of the murder suspects convicted, all of them are men. All of them are men. So Bramwell was asked, why is the judiciary dealing with the boy child badly? Yet, the only lady who was at the murder trial, Maxine, was released, was acquitted. Bramwell went to the records and found out that among the people who are being convicted, 1 is Obado, 2, Peter Mugure for killing his wife and children in Nairobi, 3, in Nakuru High Court, Francis Kiarie, a police officer, was found guilty for murder, for fatal shooting. Also in Nakuru, Isaac Lekachuma, an AP officer, was convicted of the offense of murder for the 2017 shooting. In Kisumu, Justice Omido sentenced to death Shem Akuku. In Mombasa, Justice Wendy Misheni convicted Mandi Jilani, Makonde Lura, and Ngira Karisa Chalo for strangulation, murder. But justice, a judge in Nairobi, did not put Maxine for trial. This is the ruling. Why did the judge in Nairobi not find guilt or did not get to put Maxine Wahome to stand to defend herself? This is what happened. We found the ruling where it is said, and I read, upon arraignment of Maxine Wahome, the accused, the court was informed by the Director of Public Prosecution that she was committed the offense of murder, contrary to Section 203, as read with Section 204 of the Penal Code. That is the offense that Maxine was charged. What were the issues in this matter? It says, the accused was held that at the time of the death of the husband or the friend, they were staying together in an apartment. 2, that an argument arose and they fought. She locked the door. And when she locked the door, the accused could not be taken to hospital. The accused later was taken to hospital and later succumbed to the injuries that were there. Paragraph 53. The accused stated to be 24 years at the time she was involved with the deceased was 50 years. Maxine was 24. The deceased was 50 years. On the fateful night, she went out with friends and her sister. She returned home at 3 a.m. Prior to the returning home, there had been communication between her and the deceased person. Paragraph 56, she says, the deceased always was very insecure. He could call severally, call where are you, call where are you. And this is the issue. So the people testified from paragraph 59. PW1 said she had known, that Maxine had known the deceased for 7 years. She described him as a woman batterer whose actions amounted to domestic violence towards intimate partners. During her stay at Preston Court for 7 years, she saw 6 to 7 women cohabit with the deceased and leave. He was not kind to them, that he unleashed physical violence on the women and only one had a child. This is the first witness who said and described the deceased as a serial batterer who every year was cohabiting with one woman. PW2, the witness number 2, said she rushed to the house upon being notified by the first witness. He rang the door bell, which was partially opened by the accused. He heard the deceased who was making noise, uttering unprintables. Sorry, Court Helicopter will not put these unprintables on our channel. It is bad. The language is bad. Then the deceased retorted, "Leave my house." The scenes officer, the crime scenes officer, paragraph 62, says he took photographs and observed blood stains on the stains that contained to the rear balcony. That is what he found. He saw a broken window glass and a soda water bottle. He confirmed that the blood stains on the door glass as well as the debris from the broken door glass were outward from the sitting room. The investigating officer says the blood stain and the glass that broke from inside the house, not from outside. Paragraph 63. The investigating officer said on cross-examination, he stated that it was possible for a person to kick the first, second, and third window panes, and the foot getting stuck in the glass would then be cut deeply. That it was possible that the person kicked, the deceased kicked the glass because of the blood stains. That he found the penknife and piece of metal of interest because he did not find a panga or a knife. So the investigating officer is saying the window pane was kicked from inside. The blood stains were there. So the deceased was inside. Remember the evidence of Maxine. Maxine is outside the balcony. The deceased is inside. This is the evidence of the accused person. He checked in paragraph 64. They did a check in the whole house and there was nothing. The baggage, the clothes, nothing had blood on it. The judge went further and found out that the investigating officer Koprangote argued that the narration by the accused was not such. She stated that the accused may have been pushed the deceased to the wall since it was reported that the two were fighting. The evidence of the prosecution is that Maxine pushed the deceased to the wall, and that is where the wall cut him, the window pane cut him. The judge went further and dismissed that argument. Of great importance is the forensic analysis, and here Vise explains why Maxine went away. Number one, various items were collected from the scene and they were subjected to analysis of the government chemist. Listen, number one, these items included a branded Mirage blue tobacco with the unknown substance. When it was taken for analysis, traces of cotinine and alkaline were detected in the liver sample of the deceased, and the same alkaloid was detected on the sachet. Upon postmortem, the samples from the liver were removed. They contained alkaloid which had been found on the sachet. That's number one. Point number two, traces of ketamine, which is a narcotic drug, was detected in the stomach samples of the deceased. Ketamine, an alcoholic analgesic drug, was found there in the sample of the blood from the stomach. 3. A bottle branded Jameson whiskey with some liquid was found to be ethanol at a concentration of 40% volume. The fourth evidence, there was a bottle containing ethanol at 40 VV%. Fifth, drugs contained glucophage and anti-diabetic drug amlodipine were found. 6. Anti-hypertensive drugs were found. When they were analyzed, all of them contained ketamine, which is used as an stimulant, which can also cause hallucination. So the question is, did the deceased, the rally driver, get hallucinated from this? Probably that is why he could not be able to see where the door was and where the window pane was. He went thinking he has reached at the window when it was not true. Then he moves to say, number 8, blood samples were collected from the scene and a buccal swab was taken. They were analyzed by the government analysts and profiles generated. All of them matched the DNA profile of the deceased person, Assad Mansour Khan, but not the accused. None of the evidence that was picked from the house, the clothes, the buccal swab, all those things, none was linked to Maxine. They all linked to the deceased person. Paragraph 70. It is argued that the deceased sustained some swellings on the head. The defense wounds on both sides. He had wounds here, he had wounds at the head. The judge found out that the deceased was intoxicated at the time, and having bled a lot, he might have fallen on the stairs. The judge found out that he might have fallen out of the stairs. And those wounds were of that. Paragraph 71. The issue that The prosecution questions the conduct of the accused moving from the balcony area to the sitting room, whereby she locked the door from inside, and that she never attended. She never attended the burial. She did not visit the deceased in hospital, even attended burial. The judge said this was a moral question. She feared for her life, and it was uncomfortable to attend the burial, and it was uncomfortable to attend the hospital. When the judge looked at all this, in paragraph 75, the judge says, from the evidence adduced, the chain of allegations that the accused may have injured the deceased was weakened by evidence of forensic examination, which excluded the accused as the culprit. Placing the accused on her defense would be calling upon her to supplement the prosecution's case. Paragraph 76, the prosecution strongly believed that there having been two people in the house, the one who was not injured was culpable. However, an inference to be drawn following evidence adduced excludes an inference of culpability on the part of the one who was not injured. In totality, the case presented by the prosecution has failed to establish a prima facie case warranting the accused to be placed on her defense. In the result, she is not guilty and is accordingly acquitted pursuant to section 306(1) of the Criminal Procedure Code. Maxine Wahome was acquitted. So the argument that she was acquitted because she was a woman does not hold any water. The argument that the other 6 men were convicted because they are a boy child, that doesn't matter. In this evidence, one, the forensics cleared her. There's nothing showing her hand, her body on the deceased's body. 2, she was outside when the drama of death happened inside the house. 3, the deceased was drunk, and there was clear testimony that he was a wife batterer. He had a lot of domestic violence. Could the judge convict because people want Maxine to be convicted? We have put it very clearly. Courts of law are courts of evidence. If there is no evidence, the judges will acquit. Judge acquitted Maxine because there was no evidence. Wakili Dan Senomari bringing to you why the courts will always convict or acquit based on evidence as produced and the facts and the law. Keep watching as we bring to you this issue. Forget talking about gender. Forget talking about crime from the lenses of gender. Crime is crime. Wakili Dan Senomari.